persons who are supposed to be part of this success story to frustrate Chief Michael Zekome from giving him his best in this case. This case, he relatively done it on pro bono. Relatively did it on pro bono. Every strategy was deployed towards frustrating him, but he said no, because he's on a divine mandate. I want to appreciate him. I may not go into details, but I want to appreciate him so immensely for also believing in me too, and believing in my convictions and judgment too. I also appreciate so greatly the contribution of Her Excellency Mrs. Ifeanyi Kanu, the wife of Mazi Nnamdi Kanu. Her words of encouragement, wise counseling, and also believing us throughout this terrific moment period. Even when those who are also supposed to be part of this success story were ferociously working against us, blackmailing us, doing things possible to chase us away from this case, this woman remained firm, remained strong in her convictions and believed in us. I must appreciate her. Also, my thanks also go to my friend and also my client, Chike Dozem. He's a gentleman who also believed in us. It was a very hard fight. But thank God today that we have achieved the victory, the long-awaited victory. I appreciate him too. I also want to appreciate my professional colleagues who were part of this story, this success story. The contribution of my erudite head of chambers, Barrister Mrs. Chinwumeche, cannot be overemphasized. I also want to mention Mazi Nnamdi Ejiofor, and of course Ifeanyi Ejiofor, those who work tirelessly to ensure that we get to where we are today. Of course, I cannot conclude this piece without appreciating so immensely my wife, who has been there for me, for her prayers, and also my lovely children for their prayers. I cannot thank them all. My thanks also goes to the erudite, formidable media warriors, who has been there for us, who has been taking bullets for me in particular. When the enemies were on rampage, doing everything humanly possible to derail me, to distract me, they were taking the bullets for me. My thanks goes to, I will single two of them out to appreciate. Not that the others didn't contribute, they did excellent work. Because when they were taking this bullet, I was busy working. I never lost focus. I was giving my best, doing all things we can, working behind the scene to ensure that we get the best results. I will not forget to mention persons like Ifeanyi. He has done so marvelously well. I must appreciate him. I also appreciate Prince Darlington. They are there for us at every given time. They were there taking bullets for us. I must appreciate them. May they remain blessed. They are too numerous to mention. They are too numerous to mention, including Mushineke, who were there praying for us. Reverend fathers, bishops, Catholic priests, and call them, name them. Traditional worshippers who are also praying to ensure that we get to where we are today. I must immensely appreciate them. It is a time to appreciate those who work tirelessly to ensure that we get well to it, because I know that this is the end of the game, no matter what. You all were in court yesterday to hear from the court. Unfortunately, those that didn't have opportunity to listen to the judgment of the Court of Appeal, we are busy discussing issues that were never mentioned. They are discussing irrelevant issues that were never discussed even. It's important for me to say it. Yesterday, the Court of Appeal unanimously allowed our appeal. resolved the fundamental issues on the extraordinary rendition of Mazi Nnamdi Kanu from Kenya to Nigeria in our favor, and also lambasted the federal government for the executive recklessness. And it's important for me to highlight this fact. The court held unanimously that the manner in which Mazi Nnamdi Kanu was abducted in Kenya and extraordinary rendition to Nigeria was in gross violation of extant laws. Particularly those laws, Nigeria is a state party. Particularly those laws Nigeria ratified, which is today in operation. I will take the privilege of mentioning some of these laws because it's important for me to highlight before addressing press statement of the Attorney of Federation. Some of these laws the court mentioned yesterday, the court also referred to Section 15 of Extradition Act, Cap E25 LFN. This section deals extensively with the procedures for extraditing a citizen from another country, which is operational in Nigeria. It's a law ratified in the country. It's a Nigerian law. 2. Article 12, Sub 4 of African Charter of Human and People's Rights. This is a law Nigeria also violated. Also, mutual assistance in criminal matters within the Commonwealth, Enactment and Enforcement Act, Cap M24, Laws of Federation 204. This is a law operational in Nigeria. Nigeria violated it in the course of abduction and the extraordinary rendition of Nnamdi Kanu. Now, also on point is Article 1312 of the Universal Declaration of Human Rights 1948, and also OAU Convention on the Prevention and Combating of Terrorism, which also provide for stringent conditions to be adhered to in the extradition of a citizen. Nigeria was in breach of these fundamental laws. Now, the court held and unanimously that the breach of this law constitutes a bar to further prosecution of Nnamdi Kanu in any court in Nigeria. The court held that the lower court has no jurisdiction whatsoever on the grounds of this to, in the first place, even look at the trial, to start the trial, commence the trial. That the court lacks jurisdiction to defend this charge, and as such, Nnamdi Kanu should be released. Now, let me clarify. It is true, granted, that conventionally, when a defendant is discharged of offenses allegedly committed, it's expected that the state may have the right to litigate on the same subject matter in exceptional circumstances. But in this case, the court proceeded to hold that in as far as there is an egregious violation of these extant laws, that no court will prosecute Nnamdi Kanu, no court will try Nnamdi Kanu. Even the lower court will not try him. So what's expected in circumstance is for the government to immediately comply with the directives and orders of the court. As it stands today, Nnamdi Kanu yesterday becomes illegally held in the custody of the Nigerian government. Although we're expecting the order to be made available to us by 3 p.m. today, as assured by the Justice of the Court of Appeal, so we can now take the appropriate step to ensure that he's released as quick as possible. It's also good to emphasize that in a similar climate where we have constitutional democracy, where the rule of law reigns supreme, it's expected without being told that the person of Attorney General of the Federation, regardless without prejudice to his person and office he occupied, should have by yesterday honorably tendered his resignation as the Minister of Federation, because he has exposed this country to ridicule. It's not in doubt that at the point Nnamdi Kanu was abducted in Kenya, because it's also important to emphasize, just like where I listened to some people analyzing this morning, court didn't say arrest. Court of Appeal in his judgment yesterday in the unanimous didn't mention arrest. They agreed up with us in totality that Nnamdi Kanu was abduction. Abduction, kidnapping was featured prominently in the judgment of the court. They agreed with us because in the manner in which he was abducted in Kenya, he wasn't arrested. Now, And it was partial to the advice of the Attorney General of the Federation that the federal government sneak into another country to abduct a citizen without subjecting him to the extradition proceedings. And on the ground, that ground alone, the federal government, the Attorney General of the Federation should have been resigned honorably without being asked, without a further prompting. I am not contesting the fact they have right of appeal to Supreme Court. It's a constitutional right. But what is sacrosanct at this point in time is that they must wholly and in totality comply with the order of the Court of Appeal, which directed that Nnamdi Kanu should be released immediately. They will not be in breach of this order, in content of this order, and applying to Supreme Court for review or for appeal. They must comply without further ado. So it's expected, of course, they were called yesterday to when the judgment was read. But of course, unfortunately, I believe that the letter that Attorney General of the Federation, I don't think he's conversant, or maybe he has the full gist of the judgment, of the fact of the judgment delivered yesterday, because I believe he has had opportunity of reading the judgment of the Court of Appeal yesterday. He won't be writing what he said yesterday. So the federal government is being called upon as quick as possible to comply with the order of court. Now, it's interesting to mention to the public, to the world, this argument was extensively canvassed in our various applications, in our application before the lower court, and also on appeal. Now, in 2016, there's a thesis that was captioned United Nations Office on Drug and Crime, country office in Nigeria, published a 691 page of treatise titled Cases and Materials on Extradition in Nigeria. I have the book. Look at the book. This is the book. They call it Cases and Materials on Extradition in Nigeria. Now, it will interest the press and the world to know that in this book, these cases and materials on extradition in law, the forward to this book was written by no person than learned Attorney General of the Federation. He wrote the forward. Now, you understand, me and you understand what forward means. When a forward is written on a book, that means you sanctioned. You have gone through the content of that book and you sanctioned the content. Now, I will tell you something now, because it's important for you to know. Now, in this book, it's at pages 4 to 5 of that book. The Attorney General, that I mentioned to you, having sanctioned that book, critically condemned extraordinary rendition in this book. He critically condemned in page 4-5. I can give you it's very, very bulky. Condemn extraordinary rendition. In his words, quote, listen to me carefully. In his word, the AG Federation Malami stated, it is easy to confuse extradition with rendition. Rendition is a general term for all procedures, including extradition, for returning wanted persons or aliens generally from a state. Unlawful or irregular forms of returning persons wanted for trial, unlawful or irregular forms of returning persons wanted for trial or punishment include abduction. In his words, include abduction. It's not what happened in this case. Abduction and so-called extraordinary rendition. Now he proceeded. Extraordinary rendition is a government-sponsored arrest. Are you with me? Kidnap and abduction of persons wanted, accused or convicted of a criminal offense, either to the state who sponsored the arrest or kidnap or abduction, or to a willing third-party state. Extraordinary rendition denies a person of the right to challenge his transfer to the requesting or receiving state. It involves the violation of the principle of international laws, especially where the persons transferred are subjected to torture. Are you with me? Or sham criminal charge or trial. The Duke Affair of 1984 is an example of an attempt at unlawful rendition. After a coup d'etat in 1983, the federal military government of Nigeria requested the British government to surrender Umar Diko, a former minister of Federation, alleged to have been involved in corrupt practices. Now, the facts of what happened in Diko's case is very clear to the world. It's a matter of common knowledge. The British government intercepted and refused. Intercepted and refused them taking him away from the UK. Now, this is the wordings of AG Federation. So you won't tell me that it's not familiar with what extraordinary interdiction means and the effect of it on the effect of it on the state on the just state. By so doing, this man has exposed the country to ridicule. And I can assure you one thing, because I'm in this case, I can assure you one thing. Some international courts where these matters are pending are waiting for court pronouncement for Nigerian courts to exhaust their legal remedies before they can embark on their own adjudication. They are waiting. And the pronouncement of Court of Appeal yesterday is apt on the point. It will entail further actions before the international court. We also entail certain persons being blacklisted, certain persons being arrested somewhere on account of the gross violation of international laws. It will happen in the course of time. Now, yesterday someone asked about the damages payable, accruable on account of this violation of Nnamdi Kanu's right. Because of course, Court of Appeal yesterday stated clearly that his right was grossly violated on account of the extraordinary rendition, from Kenya to Nigeria. That may interest you to know that we have already filed an action before the Federal High Court, wherein we raised some fundamental issues. We have invited the court to interpret relevant sections of these conventions, charter, and theatres to determine whether the federal government is in breach of this law. Those questions have been answered in the affirmative yesterday, that the federal government is in breach of this law. That matter is pending before Honorable Justice Eko of Court Number 5 and is coming up for full hearing on the 14th day of December 2022. And in that case, what we'll be asking for now, the matters having been determined, major issues arising before the court to determine upon, to pronounce upon, have been determined by Court of Appeal. We're asking for court to award damages in the sum of 50 billion against the federal government in compensation of as reparation for gross violation of Nnamdi Kanu's right. So it's important to highlight this part. So the court didn't also condemn the executive recklessness yesterday. The court didn't stop at declaring that the lower court has no jurisdiction to defend the charge. The court also, the pronouncement of court yesterday, constitutes a further ban. You understand what I mean by constitution of a further ban? So as it stands today, no Nigerian court will ever try Nnamdi Kanu. No Nigerian court will ever entertain any charge today, as far as this matter is concerned, or any other matter is concerned, without determining the manner in which he was brought into the country. And thankfully, yesterday the Court of Appeal have resolved that issue. That judgment is a watertight judgment. Without further ado, thank you so much. I can answer your questions if any further question, please. Thank you.
Thank you very much, sir. So if I recall properly, immediately after the judgment, lately the AGF issued a statement. I think somewhere he said that what the court only dealt with was the issue of rendition. That they have 5 count charges which predates the rendition issue. And we were surprised. Is it not from the 5 count charges that you people jettisoned and filed an amended 15 count charge? So I don't know.
So let me
just
thank you so much. Obviously, without prejudice to expressing the person of Ifeanyi Ejiofor, it's important at this point for us to chronicle and also give you a trajectory of this case, because for you to understand how we started. Nnamdi Kanu was granted bail sometime on 14th of April 2017. That should be within that period. And the matter adjourned for trial to October 17th, 2017. You and I, all of you here, the pressmen, witnessed what happened between 10th and 14th of September 2017. His premises was invaded on 10th, first invaded on 10th. 3 persons were killed by Nigerian soldiers. Then on 14th, they now wait for him. During this bloody invasion, over 28 innocent and unarmed civilians were murdered, were killed, brutally killed. Now, in an attempt, they weren't killed because they want to kill them. They were killed because they were desperately hunting for Nnamdi Kanu to kill him. Then by sheer out of providence, Nnamdi Kanu narrowly escaped being killed. Now, it's elementary part of our law, legal jurisprudence, or criminal law, that when a person is facing a trial, assuming you are charged with the offense of stealing. Let me just bring it to a level you understand, and also for AG to understand too. Assuming you are charged with the offense of stealing, and in the course of enjoying bail granted by the court, you committed another offense, probably offense of armed robbery. There's no law that said that you will not be arrested on account of that offense. And it's easy for them, particularly when you are facing prosecution. They will simply, what Nigerian security agents does is for them to come to the court and wait for you on the day of trial. I will have cases of that nation, plenty of cases of that nation. They will come to that court, arrest you, or they will even file a fresh charge. Why they will arrest you is for them to interrogate you on the new offenses, then before they will file any fresh charge. Now, assuming without considering to the fact that the federal government actually wanted any form of prosecution in this case, would they have gone to Nnamdi Kanu's house on 14th of September to kill him? The answer is no. They were waiting for him to come to court on October 10th, October 17th, 2017, to continue his trial. And probably during that period, they will arrest him and investigate him on fresh offense, assuming if he had committed no offense unto law. You will investigate him on the fresh offenses, probably and file fresh charge. And Nnamdi Kanu was ready. He has announced, he has passed through pre-trial briefing and conference, preparatory for trial, fixed for 17th of October. Now, second question: had it been the federal government succeeded, God forbid, in killing Nnamdi Kanu on the 14th of September 2027, will we be talking about this charge again? The answer is no. Now, Nnamdi Kanu, when he surfaced in Israel, state of Israel, he posted an affidavit of facts, stating the facts of what happened in his premises, how he escaped, and in that affidavit, which is now before the public, he made it very clear in that affidavit that he's ready to come back for his trial, but he needs protection from court. He needs court to assure him and give him protection, and assure him that he offers protection for him to come back for his trial. This affidavit was filed in court, stating, urging the court to take the application for court to understand, inquire into what happened in his premises on the 14th of September. It was filed in court sometime that same 2017, but the court didn't hear that application. It was still filed. He didn't hear that application till this year, and at subsequent adjournment, we kept on bringing the facts of that application before the court. That application was not heard until a few months back this year when it was brought to Nigeria. It was forcefully brought to Nigeria. I wasn't heard it. Now, Nnamdi Kanu is not in Kenya. He found himself in Kenya or part of Nigeria because of an desperate attempt by the federal government to kill, assassinate him. The law is clear. This international laws we enumerated is clear. That now you want to arrest him, right? That law, the 5 count charge you're talking about, which was facing before an attempt was made at killing him, we have gone on now. To have gone now, if at all they've had submitted into traditional proceedings in Kenya. Are you getting the point I'm making now? Did you know? If they had submitted Nnamdi Kanu to extradition proceedings, then he will go through the proceedings, and at the end of the day, if the court in Kenya found him liable, then he has to come back to Nigeria to face his trial. Section 15 of the Extradition Act says that if he's coming back to Nigeria, he's going to face the trial on that 5 count charge. Now, because they didn't subject him to extradition proceeding, recognized under international laws and covenant and charter conventions, they abducted him, they kidnapped him in Kenya, then brought him to Nigeria. Now, what the court is saying, in view of what you have done, you cannot try him again. He cannot be tried, even on that 5 count, he cannot be tried again. That's what court says. Because he cannot put something on nothing and expect it to stand. It must fall. The foundation has been spoiled. You cannot build on a shaky foundation. So that 5 count charge he was facing before an attempt was made at killing him can no longer prevail in the circumstance. The court said, take him back, he has to go. Go back. As he stands today, he cannot face any charge. He's barred from being prosecuted in Nigeria in any court. Whether it's court in Adamawa, or court in Lagos, or court in Anambra, or court in Oburusuzo, or whatever you call them, or Maya. He cannot face any trial again. So, and I believe, and I want to believe too, that the Attorney General Federation is fully aware of this law. But I believe they are trying to play to the gallery. He cannot face any trial. And for them to salvage the remaining image of this country, if at all, is for them to immediately comply with the order of court of appeal. Secondly, don't recall too that the United Nations Working Group on Arbitrary Detention had on 20th day of June 2022 issued a communication to the federal government after they have gone through the processes filed before a communication before them, directing the federal government to release Nnamdi Kanu conditionally, and also to also compensate him for gross violation of his right. The government turned a blind eye to that communication, and yesterday the Court of Appeal, though the Court of Appeal didn't make reference to that communication, but on their own findings, their judgment was basically relied upon based on the facts presented before them. Of course, you had the right judge, the Honorable Justice Nikki Toby, who was specific and firm that he is not, that his judgment is based on what is before him. That he's not interested in what's being said in social media, here and there, or just interested in what people are discussing over the social media. That they are giving, and he's giving his own judgment based on what matters before him. It was a 3 hours judgment, very, very erudite judgment, impeccable judgment, unassailable judgment of the Court of Appeal. A judgment that will stand the test of time. A judgment that has been able to resolve so many contentious issues. A judgment that has been able to resolve so many novel areas of laws has been put in place today, and I commend them so much. So it was based on fact before them. There was no politics there. There was no political solution there. There was nothing like, there was no extraneous influence whatsoever. It was based on facts and laws presented before them. And if you look at the judgment, if you listen to the judgment of the court, if you read the judgment of the court, you agree with me totally that these people, that if they are going to Supreme Court, I don't want that without prejudice to them, they are right. They can go to Supreme Court. But what you are saying is that before you take up any further step, just like what happened in the case of ASU and the federal government, ASU went to an appeal to challenge the order of Commercial Court. Industrial Court. Court of Appeal said no. You are coming to my court, eh? Who goes to put him or do what? Go and obey that order. Because notice of appeal on appeal to Supreme Court cannot operate as a stay of execution. You must first of all release my client to me. Then before you go to Supreme Court, we'll come back there and sort ourselves out. That's fundamental. So I believe I've been able to highlight some of these fundamental issues that area of law. Because we need to teach them the law. We need to let them understand what law is all about. Thank you so much.
Thank you very much.
For coming.
There is
Thank you. God bless you.
I appreciate
don't understand one do and this, okay?
God bless you.
Thank you so much.
You don't have any question, Chairman?
yeah. I wanted to nip in a question.
Okay.
We are all aware, how the federal government will always flaunt court orders and with impunity. And we want to know, and also Biafrans and the world will want to know, what if the Defense Council, after going to submit the judgment to the Federation, and they refuse, both the DSS and the federal government refuse to let him go?
I can assure you 100% they can't try it.
Okay.
Because the consequences will be so dire, it will be so serious. Already they're in trouble. They're in trouble before the international community. And the best thing for them to do now is just to salvage their remaining image, just to release them the Canada can. If they want to go to Supreme Court, I will have no problem with that. But they must, as a matter of urgency, comply. They must obey the order. This is not the order of High Court. It's not of Court of Appeal. I know what it means. So they must obey it. They can go to an appeal. Go on appeal. We'll have no problem. But before going to appeal, we must obey the order of the court. You can't hold our client illegally in the custody. When the Court of Appeal has declared his detention illegal, detention and arrest illegal, prohibits them from the Court of Appeal prohibited them from detaining him henceforth. I expected them to have called me this morning to come over, but I'm waiting for. Let me just pick up the judgment so I can go and meet them. So if they say they will not obey that order, all of us are going to that naked in public. There's no going back about it. Thank you so much.
Thank you very much, Barrister. I appreciate it. Thank you very much.
All right. Thank you, my brother. God bless you.